Can you dissolve a generation skipping trust? A generation skipping trust is a type of irrevocable trust agreement that allows grantors to leave their assets to their grandchildren, skipping their children. While grandchildren are the most common beneficiaries of generation skipping trusts, anyone who is at least 37.5 years younger than the grantor and is not the grantor's spouse or ex-spouse can be named a beneficiary of a generation skipping trust. So what is a generation skipping trust? A generation skipping trust is an effective way for people with substantial assets to preserve family wealth. If the assets transferred to the generation skipping trust were left to the grantor's children through a will or trust, estate taxes, which can be a significant amount of money for large estates, may be incurred at the grantor's death and again at their children's death. But since a generation skipping trust transfers assets from the grantor's estate directly to the skipped beneficiaries, the grantor's children never receive title to the property, and therefore you can avoid an entire generation of estate taxes. Can a generation skipping trust be broken or dissolved? Possibly. Because a generation skipping trust is irrevocable, the trust cannot be broken, modified, revoked, or dissolved like a revocable trust, which can be changed or amended at any time. Still, like any other irrevocable trust, a generation skipping trust may be modified or terminated judicially using the authority found in the California Probate Code. Can a generation skipping trust be contested? Yes, a generation skipping trust can be contested. However, you cannot challenge the trust just because you don't agree with its terms. Generally, you'll need to prove that the trust is not legally valid in order to successfully contest. A few of the reasons you can use to contest a generation skipping trust include 1. Mental incapacity. For a generation skipping trust to be valid, the grantor must be of sound mind at the time that they created it. The legal standard for sound mind is relatively low and basically requires that the grantor have the mental awareness to understand what they're doing. 2. Undue influence. If the trust was created because of undue influence, its validity can be challenged. Undue influence means that the grantor was coerced by a third party to create the trust or to name a specific person as a beneficiary or fiduciary. For an undue influence claim to be successful, the level of pressure must be so severe that it overwhelms the grantor's own free will, to the point that the trust documents reflect the desires of the influencer instead of the grantor. 3. Fraud or forgery. If a trust document was procured by fraud, it too can be contested and thrown out. Fraud occurs when the grantor is tricked into signing the trust. For example, a fraudster might tell the grantor they're signing a check, when really they're signing a trust that favors the fraudster. Fraud can also involve documents that are completely forged. In these situations, a fraudster might write a generation skipping trust naming themselves as a beneficiary and then forge the grantor's signature, for example. So who can contest a generation skipping trust? Not just anyone can walk off the street and contest a generation skipping trust. In order to challenge a trust, the party must have legal standing to do so. Under California law, a party has standing to contest a trust if they have a property interest or a potential interest that will be affected by the administration of the trust. In the context of generation skipping trusts, interested parties are usually beneficiaries or trustees. However, other family members whose property interests might be impacted may also contest. Do I need a trust litigation attorney to contest a generation skipping trust? While California law doesn't require you to retain a trust litigation attorney to file a contest, you'll benefit greatly from doing so. Trust contests are complicated, and being represented by an experienced probate litigation lawyer will drastically increase your chances of success. If you want to contest a generation skipping trust, you should contact a trust litigation attorney as soon as possible. A seasoned lawyer can review your situation and advise you on the relative strengths and weaknesses of your case, the potential costs, and timeframes. Have a question? At RMO, we protect people like you every day. Give us a call, shoot us an email. The consultation's always free. Thanks for watching.